This is Michael Popok, so it must be time for Legal AF After Dark. We got a debate coming up between the two presidential candidates, one the incumbent in one corner, one a criminal in the other, or at least a convicted criminal in Donald Trump, who's threatening to lead a crime spree of kleptocracy all over again if he ever gets reelected. But in the meantime, there's a judge in New York and an appellate court in New York that have to decide whether Donald Trump should continue to be gagged. I almost said bound and gagged. Should continue to be gagged all the way through his appeal process because, let's face it, he is a criminally convicted defendant in the New York justice system. And so Judge Merchan's going to have to make that decision on full briefing by the lawyers for Donald Trump on one side, the Manhattan DA on the other. I assume Donald Trump will say, ungag me. I'm going to debate its election interference 2024. And the Manhattan DA is going to say, look at this guy. Some version of that. Will you look at this guy and what he's done and the amount of violent rhetoric that's led to death threats and assassination threats against people that participate in the criminal justice system in New York? How can you possibly think that you should ungag him? We talk about it and we analyze it on the MeidasTouch Network on Legal AF. Take a listen.
Well, let me just show you what the Supreme Court could have done and should have done, because the highest court in New York, which is basically the state court equivalent of a Supreme Court. New York's a little confusing. Their trial court is called the Supreme Court. Their highest court, which in other states would be called the Supreme Court. New York loves to just be a little tricky with law students and practitioners. They call it the Court of Appeals. So New York's highest court, though, when Donald Trump rushed to them with a request about the gag order that was imposed in the Manhattan criminal case, here is what they wrote. They said there's no substantial constitutional questions at all. And sua sponte, on their own initiative, they just rejected it. They dismissed the appeal without even briefing, because they're like, what is this? Like, what are you talking about? And that's how the United States Supreme Court should have dealt with Donald Trump's claim that you can order SEAL Team 6 to kill your political opponent. Pull that up one more time. Imagine if the United States Supreme Court, not the highest court in New York, when Donald Trump said, I can have SEAL Team 6 kill my political opponents. Wouldn't a rational United States Supreme Court say something like this? Appeal dismissed by the court, sua sponte, upon the grounds that no substantial constitutional question is directly involved. That's all the United States Supreme Court would have had to do, and then Donald Trump's case would have gone to trial. Months ago, we would have had that trial, and just like in New York, he would have been convicted, because a jury of his peers, when evidence is presented in our judicial system, an adversarial system, a jury would see it and they would go, wow, that's someone who's very, very guilty. But the United States Supreme Court's like, so maybe, just maybe, a president could order SEAL Team 6 to kill a political opponent if it is an official act. But if it is unofficial, perhaps the district court judge needs to make very specific rulings on a one-by-one basis about each specific act. There's some interesting questions. There is no. You want to talk about a history and tradition test, Clarence Thomas? You want to talk about a history and tradition test? How about the history and tradition of the United States of America was a rejection of the monarchy? There was a doctrine of absolute immunity. It was called kings. It was called monarchs, authoritarians, people who are literally above the law and can do whatever they want. Our system, we the people, created a system where it's we the people. Our system is a rejection of that. It is the most basic historical tradition analysis that you could ever give, that there should not be absolute immunity. Just me even saying the idea that a president can order SEAL Team 6 or the military to kill political opponents? What are you saying? President Joe Biden could order the Secret Service to go and just kill political enemies and then go absolute immunity? Can't do anything about it. That is being entertained as something that can be done because Donald Trump is asking for it? Like, what are you talking about? This is the United States Supreme Court that said that President Biden did not have the discretion to forgive student loan debt the way he wanted to. So you don't have the discretion to forgive student loan debt. You do have the discretion to murder whoever you want to murder under the doctrine of absolute immunity. What in the world are you talking about? And that, though, is why, Michael Popak, I think this show is so important, because we have to make these concepts accessible. We have to unpackage the way these right-wing Supreme Court justices, the Federalist Society, try to make this inaccessible to the public so that they can overcomplicate these issues. These are not complicated issues. These are fairly basic constitutional questions that are being overcomplicated in order to try to undermine our Constitution and our democracy. And I'll conclude with this. What the Manhattan District Attorney's Office also said in one of their filings is that, look, keep this gag order in place on Donald Trump. He's a threat. He's out there threatening people. He's threatening. He'll continue to. He'll threaten jurors. He'll threaten the family members of this staff. Look, the witnesses are no longer testifying. So, Judge Merchan, if you want to remove the gag order as it relates to trial witnesses, since they don't have to testify, I get that. But he can't be threatening jurors. He can't be threatening family members. That's not the United States of America. Like, what in the world are we talking about here? So that's what the district attorney's office said. And one of the things they pointed out, too, is they're like, okay, so in Trump's motion, they are whining that the briefing schedule, which has briefing done through even past when the debate's going to be taking place, that's unfair. And the district attorney's office is like, just stop whining. If you didn't like the briefing schedule, then go to the judge and ask for an expedited briefing schedule. You didn't ask for an expedited briefing schedule, but now you whine about the briefing schedule so you can complain and say, oh, this is so unfair, but you had the opportunity to make the request to expedite it. You didn't because you want to whine. And that piece of it, when they want to tear down and make a mockery of our judicial system, that's the part where I'm good with an adversarial system. You've heard me say before, I'm fine with criminal defense lawyers representing the worst of the worst people accused of horrible things. That's part of our system, even criminal defense lawyers who want to represent Donald Trump. But the moment you try to undermine the very system to create something where people can have SEAL Team 6 kill opponents, not good with that. I'll give you the final word on the show.
Yeah, no, listen, you've got Donald Trump and his lawyers who just use a fire hose to try to pressure test our entire, all the things that gird and are the guardrails around our criminal justice system, just as he tried to do with the system around our election process. We didn't talk about it today. We'll pick it up during the midweek. But, Donald Trump just filed a motion to disqualify Judge Engoron, the judge who sat through 12 weeks of trial as the trier of fact and a bench trial to determine that Donald Trump committed fraud along with everybody related to him and his organization for the last 10 years, persistent fraud, as that term is used in New York, to try to undermine the $465 million civil fraud judgment that is ultimately up on appeal because some person not related to the case went up and tried to kibitz with the judge after a hearing, a lawyer in New York, and who's not a party to the case, who's not a participant in the case, who's not a lawyer or party to the case, just a guy who went up to and did a drive-by, whether on purpose to try to get Judge Engoron disqualified or otherwise. And Judge Engoron sat and listened to him for a few minutes and then went on and wrote his decision about not incorporating anything that he learned from this guy, this sort of crackpot. And they said, aha, back in May, as reported in May, there was a meeting between Judge Engoron and this other person, and that was ex parte, which shows a purposeful lack of understanding of what the term ex parte communication means in our legal system. That's when a party or the party's counsel has a conversation outside the presence of the other party or counsel with the judge. The judge has to both stop it from happening, and if he can't, he has to disclose it immediately that happened, and then determine whether he can continue the case or otherwise. That's not what happened here. This is a stranger to the case. But all they want to do, just as they try to do with Fani Willis in Georgia, is try to disqualify prosecutors, disqualify judges, so that Donald Trump won't be held accountable for his own actions. We'll talk about that another day. But here, the Manhattan DA is right on, and Merchan is going to have to make a decision. I thought before the debate, but based on what you've just said on the timing of the briefing schedule, which was adopted basically and conceded by Trump's lawyers who don't know what they're doing in the courtroom. The only lawyer in state court, criminal court for Donald Trump that knows what they're doing is Susan Necheles, and she has receded into the woodwork and doesn't want to really be associated with the case any longer. So she's leaving it to Beauvais and Blanche, who are not state prosecutors. Our colleague Karen Friedman McNiffolo rightly talks about this food chain in our law practice, where state court practitioners and federal practitioners don't see eye to eye. They don't really practice. They're divided by two different court systems. And what we're watching is they don't know what they're doing. Just like Alina Habba, who's a dabbler in New York practice. She's really a New Jersey parking lot lawyer, parking garage lawyer. Look it up. So they screw it up all the time. Procedurally, they just don't know their way around the procedural law, the criminal procedural law in New York, or what you're supposed to do. So if Merchan is going to keep that gag order in place up and through the time until there's an appeal, because Donald Trump is a criminal, now convicted felon within the criminal justice system for New York, and still has to be regulated and administered by the judge and only the judge. And so he's not going to say, well, it's over now and you can do whatever you want and you can say whatever you want. No, if anything, the upcoming debate and the impact, as Alvin Bragg's office has said, Alvin Bragg's gotten 56, and the number's probably higher now, over 100, I'm sure, death threats to himself and to people in his office. Death threats. So has the judge, so has the judge's daughter, so has the principal law clerk for Judge Engoron, so has Judge Engoron, so has Fani Willis, so has Letitia James and everybody in her office, because of Donald Trump, not because of people who don't pick. He, as we know, in his call and response, stochastic terrorism, and he like you said, he knows what he's doing, is causing this fomenting of discontent and causing violent rhetoric to be used. We had a guy set himself on fire in the back of the courthouse during the Trump trial, right? We've had judges and their families attacked. We had Nancy Pelosi's husband, and it should have been Nancy, according to the criminal defendant, hit with a hammer over his head. Okay, this happens every day. Donald Trump doesn't care. He doesn't care. He'll do anything to get elected, or as our President Biden has said now, and I think rightly so, something is broken in Donald Trump since he lost legitimately the 2020 election, and we're seeing the ramifications of it now. Welcome back. That was a bite-sized version of Legal AF. Lawyers, we're talking about things that they know what they're talking about. How refreshing. And we do it the only way we know how, right here on the MeidasTouch Network, in a unique way. We're unplugged, we're unfiltered, we're uncensored. Sometimes we're even unhinged, but we bring it to you straight at the intersection of law and politics. We have a full-sized, fully curated podcast called Legal AF. We pulled together those top 4 or 5 stories at that intersection of law and politics, and we bring it to you straight right here with our analysis. Wednesdays, I do it with Karen Friedman McNiffolo. Saturdays, I do it with Ben Meiselas. And then we do hot takes like this one about every hour right here on the MeidasTouch Network. If you're already in the audience and a fan of Legal AF, I want to thank you for being part of that. And we couldn't literally do it without you. But take that clip, send it off to people in your life, and ask them to become part of our audience. That's how we build what we're doing here. Word of mouth, word of video. If you don't know what I'm talking about, I'm Michael Popak. That was Legal AF. And we invite you to join us Wednesdays, Saturdays, 8 p.m. Eastern time, right here on this MeidasTouch YouTube channel, where you can free subscribe and help them get to 3 million before the November election. So until my next hot take, until my next Legal AF, this is Michael Popak reporting. Heary, Legal AF Law Breakdown is now in session. Go beyond the headlines and get a deep dive into the important legal concepts you need to know, and we discuss every day on Legal AF. Exclusive content you won't find anywhere else, all for the price of a couple of cups of coffee. Join us at patreon.com/legalaf. That's patreon.com/legalaf.